I'm frequently asked, what can I do to stop a co-owner or a business partner from starting a competing business? So we start with the assumption that you guys have a business that you've started. And so the first question that we have to look at is, do you have an operating agreement or a shareholder agreement? If you do, you have to look into the operating agreement or shareholder agreement to see if there's something that would prevent your co-owner or a partner from starting a business that competes with the existing business. If there's nothing in the operating agreement or there's nothing in the shareholder agreement, don't worry yet. If you're a co-owner or a business partner starts a competing business, meaning it's directly competitive to the business that you're in, you still may have recourse because many states have laws regarding fiduciary obligations. Depending on your state, right, and what state you're in, depending on how much of an ownership interest the co-owner has, they may have a fiduciary obligation to the corporation, right, or the business enterprise, the limited liability company, not to compete. Right? What competition looks like is you're stealing clients, you're stealing leads, you're stealing opportunities that would otherwise go into the company. And so even though the operating agreement or the shareholder agreement may be completely silent, those fiduciary obligations keep co-owners and partners from starting competing businesses, because then they may be liable to the company, right? The corporation or the limited liability company or whatever entity form that you form. So those are the kinds of things that you need to be thinking about. As with anything, preventative measures avoid a lot of cost later on or costly litigation. And so if you're going to be getting into a business and you want to make sure that the co-owners and the partners are going to be giving their sole efforts to the success of this business, you want to make sure that you have an operating agreement or a shareholder agreement that has very clear language on non-competition, right? Non-solicitation, and other provisions that exist to protect them from forming a competing business, providing information to a competing business, right, that may financially benefit them, or from soliciting clients, employees, business leads, or opportunities for the company. And so those are the kinds of things that you really want to be thinking about and really communicate those expectations up front. So if you're trying to stop someone from forming a competing business, it's best to start at the beginning and make sure that you're communicating those facts to them and get it in writing. And even if you can't do it, there may be fiduciary obligations or contractual obligations that these parties have to not start a competing business. Now, just because they form another business that takes them away from putting their sole business efforts into your business, that doesn't mean that you necessarily have any rights. So if that's a problem that you may have and you want the partners or co-owners that you have to give all of their business efforts to the business that you're starting, you better make sure that you're communicating that up front, because there's really nothing, and most states are clear on this, there's nothing that stops them from forming another business as long as it's not competitive, as long as they're not stealing leads, as long as they're not stealing corporate opportunities that will take them away from this business that you guys are operating together. So again, my name is Michael Smikin. If you have any questions here at Caligy Law, we're ready to answer this question and any other question that you may have. Contact us directly. Thanks.